Mr. Florian Haugeneder. He is a co-founding partner at KNOETZL and has 20 years of extensive experience as a counsel and arbitrator under the rules of major arbitral institutions. Well, in that regard, Florian, I would like to ask you the first question. So, what ESG concerns are particularly likely to arise during the construction and energy projects, and can you explain to us why the energy and construction sector is particularly susceptible to the ESG claims and risks?
Thank you, Amela. First of all, I would like to thank the organizers for inviting me to this conference. It really feels very good to be back in Sarajevo after some time and seeing so many good friends and colleagues. Let me start by introducing the notion of ESG, that is environmental, social, and governance principles. ESG is often used in the context of sustainable investment. So basically, ESG concerns non-financial performance criteria of companies. At its origin, this is a set of criteria used to evaluate the performance of companies in areas of environment, social responsibility, and governance. And the purpose of ESG is to support investors in making sustainable investments. So the primary context of ESG is attracting capital flows to sustainable to sustainable economy, to further transparency and to further the non-financial social performance of companies. And if you look at the various EU directives in this regard, they all focus on this notion, and the underlying idea is to create an investment framework that isn't only focusing on financial performance. Arbitration, on the other hand, and I will focus here on commercial arbitration. Investment arbitration will be discussed by other panels and panelists, is adjudicating disputes between two or more parties, usually based on contract, applicable laws, or applicable rules of laws. And as such, it's not evident that ESG are relevant or can be relevant in international arbitrations, because even if ESG principles are arguably breached, the question is, does that rise to the level of a cause of action in arbitration that is based usually on an agreement between the parties. And and of course the relevance of this, and we are discussing this in the panel is discussing in particular construction and energy, the energy sectors. If you look at the facts, 38%, I have read this morning, 38% of the greenhouse emission gases originate from the construction industry, and a very large part of the energy industry. So those two industries are a huge part of the problem, and they also, if we want to change anything of the current situation, they also have to be part of the solution. Now, the question arises, and I think that is the kickoff to our panel: how can ESG play a role in arbitration? And if you look at this question, you will have to look at the ICC Commission report on resolving climate change-related disputes, because that's really a very thorough examination of the possible relevance of environmental, social, and governance issues in international arbitration over about 50 pages. So I would really recommend to read that to everyone. Now, how can it be relevant? And the first scenario is probably the easiest one, and we all know it and probably have experience with it, is when a contract contains concrete performance criteria that are not related to any financial performance, but to environment or other human rights obligations. And that is, of course, easy, and we probably have seen that. You have, for instance, a renewable energy facility, and there are performance indicators in the contract, and the question is, well, have they been met or not? Then there is the question, was it met or not? But that basically structurally is the same thing as you would have for any other contractual performance that is specifically mentioned in the contract, and there is an argument it has not been met. The second scenario, which is already a bit trickier, is when, and that's increasingly frequent in the contract practice, at least according to what I have seen, is when you don't have any concrete performance criteria in the contract, but there is a general reference to environment, to social responsibility, human rights, etc. And then, of course, you can imagine a number of scenarios where from this general reference, a breach of contract claim or other claim can be made in arbitration. For instance, one party can say the other party has breached the contract because the environment hasn't been sufficiently protected. Let's imagine construction of a road, of a power plant, of a railway, and the contract doesn't list specific environmental criteria, but the other party says, well, according to what is the accepted standard now, your performance isn't in accordance with the contract, and can request termination, performance, or damages, for instance, to remediate environmental damages. There is also, especially in construction contracts, you could have an argument on both sides of the contractor or the investor that there is the general legal framework requires a change in performance. It requires to build additional measures to build additional measures to protect the environment, to build fish ladders in a hydropower plant, to take special measures to reduce greenhouse emissions and so forth, even though it is not mentioned specifically in the contract. And on the other hand, the contractor could argue, well, I'm obliged to add specific, to take specific measures not mentioned in the contract because I have to comply with my environmental responsibility, and I need to build this and that. And that's a variation and requires additional payments. So you can, with a little bit of creativity, you can imagine lots of scenarios where on both sides, ESG, at least indirectly, can be relevant in arbitration. And then there is the third scenario where the contract doesn't say anything, but then a party claims that the ESG principles, and the ESG doesn't come out of nowhere. It's arguably based on a body of hard and soft laws, including the Paris Agreement, human rights legislation, and domestic legislation aiming to protect the environment, human rights, and social protection. Because of that, even without a reference in the contract, the applicable law requires observance of certain ESG principles, and the choice of law clauses in arbitration are arguably allow relatively easily to make such arguments, because you don't have only the contract and the applicable law, but also most arbitration rules contain a reference to rules of law, and of course you can bring lots of soft laws, international laws, general principle of laws into the game to sustain an argument that ESG principles have to be observed by the contract partners. And what that means concretely, of course, has to be determined in the circumstances of the case. Just following up on Anna's excellent presentation, I mean, you have the famous Shell case where a Dutch district court in 2001 held that there was a concrete obligation of an individual company to curb greenhouse emissions, despite the fact that there wasn't any legislation in place that required a specific to achieve a specific target at the time. So it's possible, and I would submit quite likely, that in the next 10 years to come, we will see a lot more of these arguments made that the existing legal framework will allow to derive concrete obligations of individual companies to reduce greenhouse gases or to achieve other environmental performances, even though there is no directly applicable legislation, or at least no explicitly applicable legislation on this point. Now, and that's an open area where basically we will see how the case law and the arbitral practice will develop. My prediction is that we will see lots of more cases where this will play a role. Coming to the fourth scenario where ESG principles may play a role, and I think that's a lot more concrete, that's investor disputes based on the non-observance of ESG principles. So imagine you have an M&A transaction, and there are, of course, usually lots of reps and warranties, and in the transactions that I have seen recently, there are also reps and warranties regarding ESG principles and the observance of those principles. Imagine they have been, these reps and warranties have been included in the contract and have not been observed, as it turns out, then this is possibly a quite straightforward cause of action for in an post-M&A arbitration, and you could have two scenarios. One is basically that the non-observance as such reduces the company value, and then the target company may be faced with claims from investors or third parties, and that may have a direct impact on the company value. Suppose there is an arbitration agreement in the M&A transaction that will lead to a straightforward post-M&A arbitration. And then there is the fifth category that I could identify, which is a submission agreement after the dispute has arisen, and that is of course open to a broad area of disputes, including mass claims against big companies, and there is the question, and I would submit arbitration is at least in the transborder issues and more global claims perfectly suited to administrate such claims, including mass claims. Now, let me conclude this kickoff by mentioning why I would submit that arbitration is well suited to adjudicate these claims, and I would also submit, given the importance of the topic and the very likely dramatic increase of such litigations, arbitration has to adapt to such claims and has to be open to such claims, or otherwise arbitration will become irrelevant for that part, which is a big part of the possible, let's say, market share of arbitration in dispute resolution. First, the procedural flexibility. So you're not stuck with more rigid national procedural laws. You have the possibility to have multi-party, multi-contract arbitration. You can adopt either, depending on the circumstances, you can adopt a confidentiality regime, but also transparency regime. Transparency is often said arbitration is not transparent. If I compare it, for instance, to Austrian court litigation, I would submit that most of investment arbitration is more transparent than court litigation, because you have all the decisions published, including the names of the parties, which you don't have in many domestic jurisdictions. You can go to the hearings, but that is it. You don't, or not always, see the judgments. And as I already said, there is a quite flexible regime regarding the applicable laws, allowing arbitral tribunals to take into account international law, general principles of law, rules of law, including possibly all sorts of soft laws. And to conclude on that, I would submit also that the arbitration practitioners show the necessary intellectual flexibility and curiosity to deal with such claims. Thank you.